Right here it says the court ruled that the Second Amendment to the U.S. Constitution confers an individual a right to possess a firearm for traditionally lawful purposes such as self-defense. In cases in the 19th century, of course, the Supreme Court ruled that the Second Amendment does not bar state regulation of firearms. Now, in law, there is federal law and state law. Okay? Federal law is the Constitution, right? Every state has their own constitution, right, which is subordinate to the feds. It says right here, the preemption doctrine originates from the supremacy clause of Article 6 of the United States Constitution. This doctrine states that any federal law, even if it is only a regulation from a federal agency, supersedes any conflicting state law, even if that law is part of the state's constitution. That means there's federal law and state law, right? Federal law being the fucking Constitution, state law being the state constitution. That means any law that's in the state constitution doesn't apply, right? Or doesn't have the authority to override federal constitutional government law. This right here is for all the police. States cannot ignore federal law. If state law contradicts federal law or the Constitution, that a state has more lax drug laws than federal government probably does not result in a conflict between state law and federal law. It simply means that the states will choose not to prosecute people for certain activities. That means if a state has a fucking gun law, right, and that gun law goes against the Second Amendment, which says the right to bear arms shall not be infringed, that means that there's a conflict between state law and government law in every single state that we have in this country. Now, this says under the doctrine of preemption, which is based on the supremacy clause, federal law preempts state law, even when the laws conflict. Thus, a federal court may require a state to stop certain behavior it believes interferes with or is in conflict with federal law. That means if a state is ignoring, which is called nullifying federal law, which they're doing with the right to bear arms, when the feds find out, the feds should say, hey, knock it off, let that guy go. Right? As long as you're not shooting somebody or robbing something with it, there's no reason to lock them up, let them out. Now this right here says supremacy clause. Article 6, paragraph 2 of the United States Constitution is commonly referred to as the Supremacy Clause. It establishes that the federal Constitution and federal law generally take precedence over state laws and even state constitutions. That means if there's federal law, which there is already, federal law has been around, that federal law has been around since 1776. It's 2017, all right? They make state laws every day. They make statutes and codes and state laws every day. None of them state laws or state constitutions override federal constitution. That's what precedence means. Federal law has more authorization than state law, period. Here's that word again. States are not entitled to nullify federal law. Any law that interferes with a valid federal law is unconstitutional. The federal law is supreme over state law. And that was said August 29, 2014. That's basically what it says. I mean, there's really nothing else. Nullify, right? Nullify basically means override. Like, okay, well, there's a Second Amendment protecting citizens from bearing arms and having guns to protect their families and all that, right? But we're going to nullify that and lock this guy up for just having a gun, not for using it. He didn't shoot at anybody. He didn't rob a bank. He was walking around with it, or he got pulled over, police seen it, or tricked the guy into searching the car, finds the gun, locks him up, he goes to